Okay, this is Yusef back with another video. And today I'm going to be discussing some criminal aspects of this redemption thing that we're going through. You know, when I was first brought into this, and I was being constantly told that it's not really criminal, it was civil. I was listening to Gene Keating. He said it's all civil, it's admiralty. The jurisdiction of admiralty is civil. And to get away from the conspiracy theory thing, because it's like, oh, that's conspiracy theory. So what I started to do is I said, you know what? I'm gonna start looking in their law books and see if I can find some evidence that all of this is real, utilizing their law. And I kind of took from a video called The Occult World of Commerce that I have posted here on my YouTube page, where Jason Whitney was saying it's like an overlay. What they're doing is like an overlay. And I always remembered that. So as I progressed in my understanding of all of this information, I started to notice some things. It's the words. They hide everything in plain sight using the words, and and you got to also know how to cross reference, um, you know, the statutes and so forth. Everything's not in the same statute. Like, the criminal code and so forth. And I'm going to show you that in a minute. Like here in Georgia, Title 17 and 18 go together. But if you don't know that, you'll never look in Title 18. You'll only, stay in Title 17. I'm going to show all of y'all what I'm talking about. And hopefully you can utilize what I'm going to show you in your own respective states and, start doing some deeper research for yourself. Now, I started doing this in Georgia because I was doing some state cases here in Georgia, and I was studying Title 17, which is criminal procedure in Georgia, and I came across a real interesting law, and I'm going to show you the difference also why you go to the law library versus staying on the internet, looking on the internet and looking up stuff on the internet. You're really not going to get everything that you need. So let me show you this real quick. Okay, I'm back. And I found something in the Georgia code that was very, very interesting that led me on my trek of investigating all this information on a deeper level. And it's OCGA 1711-1. And what made me even start looking at this was a document called Creditors in Their Bonds, the hot potato game. And let me read that for you real quick before we do this. And this is coming out of a document called Creditors and Their Bonds. And it's a section that talks about the hot potato game. And what the hot potato game is, how liability for the cost of the case can switch hands so much. So I think it would be appropriate for me to read this for you first, because it's going to kind of get you the mindset of how, when I started doing my research, why I started researching all this stuff. But it has to do with the public defender and the position that he really holds. And it goes on. It says, if there is a court involved, the judge may appoint a public defender for the defendant. You are not the defendant. The straw man named on the presentment was chosen to be the defendant. Remember rule number 1: the public and the private can never be mixed. They can't do it, and you can't do it. They don't ever mix them, so be careful that you don't either. If the defendant has a public defender, this is good. When the prosecutor signs the complaint, verifying it, and its signature is notarized, he has taken on the liability that may follow in the event it is discovered the complaint is not valid. He has taken a chance because at that point, he is the only attorney of record. He has filed a form of notice of appearance by filing the complaint or filing the grand jury indictment. He technically represents the defendant until someone takes his place. He's counting on someone appearing in the case to defend against his complaint. If that doesn't happen, he is the responsible party and liable for all the cost prayed for in the complaint or associated with the statute violation. If that does happen, he is off the hook. Almost 100% of the time, that is what happens. He is pretty safe taking this chance. Usually, the straw man named on the complaint gets a good attorney to defend him. That means the defense attorney has taken on the liability, right? Not so fast. He does not take on the liability until he signs a notice of appearance and files it in the clerk's file for that case. Once he is the attorney of record for the defense, he is on the hook. Now, he has to get someone to take his place. The likely taker of that position is the straw man named in the complaint, indictment, or traffic ticket. The straw man can't talk, so someone has to represent it. Usually, that is you, because you have a point to make, or a lesson to teach, or testimony that will prove your case. Wrong choice. This is almost always the losing proposition. Really good off point paperwork has been put into court for decades with very low success rate. The only way to win is to let the state win. I love a win-win situation. How can you win and the state win at the same time? If you accept and return the presentment and exchange it for exemption for the discharge of the charges, the state gets the credits from your exemption and you get the discharge when you bond the case. Well, that sounds easy, right? If the defense attorney can get you to act as the trustee of the straw man trust named on the complaint, the defense attorney is off the hook too. It is just a series of passing the buck, a hot potato game. The one who ends up with it has to pay the bill. The prosecuting attorney starts with it. It goes on to the defense attorney if he files a notice of appearance, and then on to the straw man if you volunteer to defend, argue, testify, or join in the action in any way. It eventually ends up in your lap. You are stuck with the public liability unless you accept and discharge it from the private side. Hot potato game, prosecuting attorney, defense attorney, straw man, and you. Now, when I first read this years ago, I used to look in uh, the filings and notice how attorneys would file their notice of appearance. I noticed the time of it, and I started putting a picture together that something was correct about what was read right here. It's like, okay, these notice of appearance, when they put in a notice of appearance and they get the liability, but they got to make, but the first, because I noticed this is what they will do. Once they put in that notice of appearance, your defense attorney, the first thing he's trying to do is get you to plea out. Because when you enter a plea, you accept all the liability. So I'm noticing that, I'm like, wow, as soon as he, even and sometimes what they'll do is they'll file their notice of appearance and then immediately after that file your plea agreement or whatever. They try to get you to plea out as fast as possible. And that was just something I started to notice and pick up. So I started to investigate it because I wanted to see if there was any um, truth to any of this. I was reading where Gene Keating was talking a lot about this on the criminal cases, and I'll probably do something on his stuff too. He was talking about the facias uh, and of how this is all civil and so forth. It's a lien, and so I came across this in Georgia. It's called um, criminal procedure, assessment and payment of cost of criminal proceedings, imposition of cost on prosecution upon defendant generally. And I started reading this and I said, the cost of a prosecution, except the fees of his own witness, should not be demanded of a defendant until after trial and conviction. If convicted, judgment may be entered against the defendant for all cost accruing in the committing and trial courts and by any officer pending the prosecution. The judgment shall be a lien from the date of his arrest on all the property of the defendant, on all the property of the defendant. The clerk shall issue an execution on the judgment against the property. All right, so we got a lot of things in here. This thing was chock full of so much information, but you're not going to find it on the internet. And this is what I try to tell people. I said, look, you got to get away from the internet because all they're going to do is just give you the code. You're not going to get the judicial interpretation of this because a layman may be on the street and read this. And if you don't know anything about legalese, you might think may means that you have some sort of discretion or something like that. When people who have a little bit more experience know that the word may means must, or you need to go and check and see if they have the definition of it in the statute. So I went ahead and went to the law library okay, and found the official code of Georgia annotated. And I went ahead and looked this up. I said, man, I want to look this up and see if there's any truth to this. And remember, we're talking about the prosecutor and the defendant. So I went and I got it. And I noticed that you have OCGA 1711.1 is imposition of cost of prosecution upon the defendant generally, and OCGA 11.4 is imposition and costs and jail fees upon the prosecutor or complainant. So I'm like, okay, so there's one. It's one where in one situation you'll have to pay, and another situation the prosecutor will have to pay. So I said, that sounds a lot like what's going on in creditors and their bonds. So I went on down here and I read this. And of course, we have the same thing. But see, in here, we got the judicial decisions and where it explains what is going on, everything that is said up here in this statutory code. So down here, we get some interesting things. Like right here, it says, judge has no discretion in the matter of taxing costs. Now, we got to look at this word tax real quick. Let's stop for a second. Let's look that up. Okay. And now I'm coming out of a Black's Law 8th edition. And you can see right here we have the word tax. And it's always important for you to look up these words because a lot of times you think you know the definition of a word until you look it up. And often you're very surprised. And additionally, you can often gain some keen insights that will lead you into some deeper understanding of the particular subject that you're studying. Right here it says tax, a noun, a monetary charge imposed by the government on persons, entities, transactions, or property to yield public revenue. Most broadly, the term embraces all governmental impositions on the property, property privileges, occupations, and enjoyment of the people, and includes duties, imposts, and excises. Although a tax is often thought of as being pecuniary in nature, it is not necessarily payable in money. Now, this was a very, very interesting sentence. I mean, and the average person, when I tell people this, it's like you really begin to see how dumbed down society is because people are just looking like in a blank stare in outer space, like, what are you talking about? I mean, pecuniary means money, okay, and it's not necessarily payable in money. Well, how else can you pay something? Like when you go to jail, they tell you you have to pay your debt to society. You pay with your labor. There's a lot of different. It says not necessarily payable in money. A tax is not necessarily payable in money, and this goes right over so many people's heads. It's incredible. Um, Now, what was really interesting, it says taxes are the enforced proportional contributions from persons and property levied by the state by virtue of its sovereignty for the support of the government and for public needs. This definition of tax is often referred to as Cooley's definition, has been quoted and endorsed or approved expressly or otherwise by many different courts. While this definition of taxes characterizes them as contributions, other definitions refer to them as imposts, duty or impost, charges, burdens, or exactions. But these variations in phraseology are of no practical importance. So I looked and said, okay, it's a charge. And you see up here, it's a monetary charge. They say they're going to give you charges. Okay. So now, when we go back again and we read the criminal code, and we can see the judge has no discretion in matter of taxing the cost, it gets a little bit like some insight in this. Okay, why are they using this word tax? So let's look at it a little closer. It says that these judges explain these statutes, they construe them because their job is to interpret the law. And it says, while the word may ordinarily denotes permission and not command, the use of the word in the second sentence of this section cannot be construed to mean that the trial judge is vested with discretion in the matter of taxing the cost against the convicted defendant. There is no provision of law for the payment of the fees of the officers of the court when the judge, in the judge's discretion, fails to tax the costs against the convicted defendant. And it cannot be assumed that it was ever intended that the compensation of these officers should rest in the discretion of the judge. All right. So right here, they make some reference and makes it seem like, okay, well, this is to pay for, you know, um, as if it's only to pay for the fees of the officers and so forth. All right. And we're gonna see that we're gonna get some deep understanding of that. It says right here, and let's go down here. and you're going to see some more interesting things. And right here, this is a bond. Okay, the bond, if no supersedious is obtained, which is putting in a bond, the clerk of the trial court is entitled to have judgment awarded against the defendant for all the costs accruing in connection with the defendant's prosecution of a writ of error. All right, to the Court of Appeals while the defendant's case is pending in that court. Everything is about bonds. And notice that this is criminal now. We're in the criminal section. Okay, imprisonment for failure to pay cost. Once a judge guilty of a misdemeanor and sentenced to pay the cost of the prosecution and the default of payment thereof to be confined in the chain gang for a stated term, cannot be held in custody or compelled to labor on the chain gang for fees due officers of court for services which the officers were required by law to render in proceedings instituted by that person, subsequently to the person's conviction and sentence, to review and reverse such judgment and sentence, though liable under the judgment for such fees and costs. Once again, it's showing your liability. But right here, this is what I want to get to. Here it goes. Costs are collectible by levy of a five fee. And if you never had heard what a five fee is, it's a facias. I'm going to show you. Costs in a criminal prosecution are collectible of the defendant by the levy of a five fee at the termination of a prosecution if it finally results in the conviction of the defendant. And right here, I'm going to show you what a five fee is real quick. Okay, and we're back in Black's Law 8th edition, and you see we have fieri facias, okay, which is, of course, a five fee, all right? And it says Latin, that you have caused to be done. You did it. A writ of execution that directs a marshal or sheriff to seize and sell the defendant's property to satisfy a money judgment. Okay, so they're seizing and selling your property. What property are they seizing and selling? Okay, if every time you're convicted of a crime, okay, they have to find you guilty. They have to put these costs against you and seize your, what property are they seizing? What if you're homeless? You don't have any property, and they have to do that against everyone. Okay, it receives its name from the Latin words in the writ quod fieri facias de bonis et catilis, that you cause to be made of the goods and chattels. Look at this, man. It is the form of execution in common use in levying upon the judgment debtor's personal property. The writ of fieri facias, commonly called a writ of fife, which commanded literally that you caused to be made, was an early common law means of enforcing payment of a judgment. It was in effect an order to the sheriff of the court to enforce a judgment against the debtor by levy, seizure, and sale of his personalty to the extent needed to satisfy the judgment. All right. So right here we can see, well, they try to tell you, well, it's not civil. Okay, well, right now we are in the criminal code. This is Title 17, all right, and everything in there. This is criminal procedure. Everything in here we're talking about. So what are they? First of all, what are they talking about? There isn't any such thing as this is not civil. Well, let me show you something else. So we can see right here that this is some sort of debt collection. Well, let me show you something else that looks interesting too. Okay, this is Georgia's debtor creditor law. Okay, and you always want to start out at the beginning of the statutes and read and see how statutes are applied. And I think it's right here in the general provisions. And right here, 1821, creation of relationship of debtor and a creditor. It says, whenever one person by contract or by law is liable and bound to pay to another an amount of money, certain or uncertain, the relation of debtor and creditor exists between them. Okay, now right here they tell you very clearly what is going on. So if a debtor and creditor relationship is created, then you need to be looking in this chapter. Also, doesn't matter if it's a criminal case. You need to come over here and look, because there's a debtor-creditor relationship that's just been created, and you need to be reading debtor and creditor law. And you're going to find something that's real interesting here in the general provisions, that in the attachment proceedings, I had to find out what a writ of attachment was. And I think it's these general provisions. And right here it says the bond requirements. Okay. So right here it says no writ of attachment shall issue unless accompanied by a bond with good security, condition to pay the defendant all costs and damages that he may sustain in consequence of the issuance of the writ of attachment. In the event that the amount claimed to be due was not due, that no lawful ground for issuance of the attachment existed, or that the property sought to be attached was not subject to attachment, the bond shall be a sum equal to twice the amount claimed in the plaintiff's application. And this is like a replevin bond, where it's talking about this. And they talk about this replevin bond in creditors and their bonds and so forth. But what is real interesting about this is this writ of attachment. Let's look at what a writ of attachment is real quick. Okay, and I'm going to stop by attachment, and then you see attaching creditor. Okay, attaching creditor. See, this is some creditor and debtor stuff. An attachment. The seizing of a person's property to secure a judgment or to be sold in satisfaction of a judgment. Okay, so that is the fundamental definition of attachment. Now let's look at what a writ of attachment is. All right, so down here in the second sense of the word, you can see the arrest of a person who is either in contempt of court, and this is what you find in admiralty, it's always contempt, or what they call contumacious conduct that gets you arrested, or to be held as a security for the payment of a judgment. Okay, this goes all the way back to Edward I when we're talking about the statute merchant, when you could be held as security for a judgment. So right here, we're seeing that, okay, one of the definitions of an attachment is the arrest of a person who's they're going to hold you as security for the payment of a judgment. All right, a writ ordering legal seizure of property and so forth. All right, so when we go back over here, it says no writ of attachment, or we saying no warrant for an arrest shall issue unless accompanied by a bond with good security, condition to pay the defendant all costs and damages that he may sustain in consequence of the issuance of the writ of attachment. This is what used to happen in admiralty. You had to go to the sheriff and issue what is called a replevin bond. Let me show you that real quick in creditors and their bonds. Okay, now we're back in creditors and their bonds, and I'm just kind of showing y'all how when I first started reading this, what led me to start investigating these bonds and everything. And here right here is in the section is case bond. It says this bond is in the nature of a replevin bond. A replevin bond was formerly used in common law, equity, when there was a dispute and one party chose to file a claim in court against another party in possession of property in dispute. The moving party was required to bond his charged claim before he could get temporary possession of the subject property. The replevin bond was double the value of the subject property. Part of it was to indemnify the sheriff who seized the subject property from the defendant in possession. The other part was to guarantee the defendant would be reimbursed at least for the value of the seized property if it were not returned to him in the event he won the case. In equity, all charges need to be bonded. You've heard put your money where your mouth is. That is what is happening when charges are brought in court and the moving party bonds the case. This policy assures the defendant will not be damaged by an unsupported complaint. Charges are rarely bonded in modern court procedures until after the case is decided. By that time, the defendant is almost always in dishonor, so the prosecuting attorney can use the defendant's dishonor to bond the case. It is really the defendant's representative that is bonding the case. Again, it is the man's credit that gives life to the bond. If the defendant is in dishonor because of what his representative, trustee, said or did not say or did not do, it is the trustee's credit that is used to satisfy the debt or discharge the bond. You can voluntarily bond the case if there is no bond already in the clerk's file. Be sure to get a certified copy of the docket sheet as evidence there is no bond in the case before you issue your bond. When you bond the case, you are the creditor and the creditor wins. If you bond the case, become the creditor, and then dishonor the judge, the attorneys, or the process in any way, you will lose your position as creditor and go back to representing the defendant. All the dishonors are pinned on the defendant, even if you are the one who went into dishonor through your own words, through your words or your actions. The defendant cannot talk or act. It all comes from you. If you bond the case and underwrite all the obligations, loss, costs of the honorable citizens of the state of whatever, that would include the attorney as long as he is honorable. If he is not, he refuses the indemnification and volunteers to have his dishonor give the commercial energy to the settlement. It is up to him. The judge will go along with what he requests. Usually the attorney will tell the judge that the plaintiff moves for dismissal. So right here, this case bond, I want to go back up here when it's talking about double the amount. Okay, and this is what a replevin bond is. And this is what we're looking at when we get back over into 18310, it says where it has the bond shall be a sum equal to twice the amount claimed to be due in the plaintiff's application. So these are the bond requirements. If you're going to, if there's a creditor-debtor relationship, there's always a bond requirement to be put in, okay, on both sides that the prosecution has to have before he issues a warrant for someone's arrest. And they even have down here the forms of the attachment, which is really interesting. Let me show you this. They got what it looks like, the attachment, and down here they got the actual bond that you're supposed to use. I think it's is it right here? Yeah, right here. Here's the bond right here. All right, so this is that you copy this out, put it in a caption. We, the principal and surety, jointly and severally acknowledging ourselves bound unto the foregoing defendant in the sum of X Y dollars, subject to the following conditions. The said principal is seeking attachment against the said defendant, which is now about to be sued out in the court of county. Now, if the said plaintiff shall pay all damages that the defendant may sustain, and also all costs that may be incurred by him in consequence of suing out such attachment, in the event that the said plaintiff shall fail to recover in said case, then the bond shall be void. Now, right here, this is where we get into, you see how they're hiding things in words? Okay, they're using this word attachment instead of a warrant for an arrest. Now, let's get back over into the criminal code because there's something else that I want to show you. All right, so now this was 1711. We remember right here in 1711 for imposition of costs and jail fees upon the prosecutor or complainant. Well, let's look down here real quick and let's see if we can find something to substantiate that real quick. And down here we get to 1711 for, and you can see it right here. Imposition of cost and jail fees upon the prosecutor or complainant. The prosecutor's name shall be endorsed on every indictment, and he shall be compelled to pay all costs and jail fees upon the acquittal or discharge of the person accused when 1. The grand jury by its foreman on returning a no bill expresses as its opinion that the prosecution was unfounded or malicious. 2. A jury on the trial of the prosecution finds it to be malicious. Or 3. The prosecution is abandoned before trial. When it is thus abandoned, the officer who issued the warrant shall enter a judgment against the prosecutor for all cost and enforce it by an execution in the name of the state or by an attachment for contempt. We already see that an attachment is a warrant for arrest. So now we can begin to see why the prosecutors don't never drop the charges. You're like, why won't this guy drop the charges? He's relentlessly, he won't drop the charges and anything. Well, that's why, because, and why also you don't go into the grand jury hearing and everything. He has to make sure he gets a indictment against you, and he has to make sure that he gets a conviction against you. If he don't do any of those things, he's the one that's responsible for paying all the cost. This is why I'm telling you to read this document, creditors and their bonds. Because I went and did the research on it, and you have to really have an eye to kind of see what is, because of the language that they're hiding things in. If you don't really understand what a writ of attachment is, a fieri facias, what a case bond is, even in here, there is a picture. Even in here, there is a picture of the bond that's used to bond the case. All right. And you can see right here, when you look at that, and then you look over here and you look at form of bond over here, you begin to see that this is the bond over here. We, the principal, all right, this is the bond that they have to put in. And then creditors in their bonds, they also had the bond that you put in. And this is why I began to see, I said, you know what, this document, somebody whoever wrote this, they had some very good insight and some keen knowledge about a lot of different things and on a level that I hadn't seen before. But if you start doing the research, see, a lot of you will just read documents and you don't do the research. And especially these naysayer guys, who never go to a law library, who don't look up definitions of words or anything like that, who want to go in and who are teaching you to go in and argue in a case on traverse charges and things of that nature. That's a lot of these new school guys who don't have enough, their depth of learning is just not there. They haven't been doing it long enough. So they're teaching you incorrectly. But the thing is that you have to go in and you have to start doing research yourself. Don't even listen to me. You got to really go and do your own research. But you need to really learn and see, because When you look in the codes and everything, they're taking all of this from the common law. And that's what made me start to go and look in the statutes to see if they disguised it in some kind of way. But this is evidence that, yeah, there is a debt collection. Okay, somebody's got to pay the cost. Okay, are you going to pay your debt to society? It's going to be you if you don't bond this case and accept the charges and so forth. So this was just my little short presentation about this. Hopefully this will encourage some other people to do their own research. In other states, it's not going to be listed the same way. However, if you stick with that word attachment, it will start to help you see what is going on. If you stick with the word attachment, okay, the attachment and everything, and stay right there, because they have the same thing in all the states. The statutes are in different places and so forth, but I've always found this thing with bond requirements and the creditor and debtor law and so forth, how it has to be twice the amount and so forth. You'll see all of this. But the first thing you have to establish is that there is a creditor debtor relationship. All right, creditor and debtor relationship. All right, once you have established that there's a creditor and debtor relationship, then you can go into the creditor and debtor law. And that was the whole purpose of going into the criminal code and seeing it say you're liable for all costs. All right, and they're going to execute that on you. And let me show you something else that was really interesting. And that was funny. It says cost of feeding prisoner while prisoner is in prison awaiting trial, or part of court costs collectible from the for defendant. So while you're sitting in jail eating hot dogs and bologna sandwiches and everything, you think you're getting free food. Oh no, when they convict you, that's part of the cost they're going to collect from you too, from the execution on against your property, as it says up here. They're going to execute against your property. All right, it says the judgment shall be a lien from the date of his arrest. This is what people are saying, they're accessing your TDA account. No, and people just regurgitate what they hear. This is about creditors and their bonds. These people that create bonds, and bonds is an evidence of a debt. Okay, when you get a lien, they'll put a lien against your property, your estate. Okay, your freedom is your property. Your name is your property. Your children are your property. They put a lien against your estate. All your property. It says right here, all the property of the defendant. That's everything that could possibly be associated with you. And they put a lien, and from a lien you can create a bond, and from a bond you can sell it. I hope this is beginning to make sense to all of you. And all you people giving done down, I got a middle finger for you, because you assholes ain't putting up a video, and you don't know none of this stuff. So kiss my ass, all right? You need to come. I'm trying to show these people this stuff. And the thing is this is a lien. Find out. You will find it in these books. Go and research it for yourself, and you're going to find out. Peace to the gods. I'm out.